And still on the ruling, the Supreme Court judges delivered judgment on the 9 pertinent issues raised by the presidential contender Raila Odinga and his running mate Martha Karua. Part of the issues raised by the petitioner centered around the split between the Independent Electoral and Boundaries Commission chairperson Wafula Chebukati camp, supported by 2 commissioners, Abdi Gulie and Marjan Hussein Marjan, and that of Vice Chairperson Juliana Cherera, who sided with 3 other commissioners, including Justus Nyangaya, Francis Wanderi, and Irene Masit. Chepchumba Sharon brings us the full report on how the court issued the judgment.
The Supreme Court on Monday, September 5, upheld the victory of President-elect William Ruto in the August 9th polls. While delivering their judgment at Milimani locals, the 7-judge bench ruled on 9 contentious issues, highlighting issues such as the credibility of the Independent Electoral and Boundaries Commission (IEBC), whether Ruto attained 50+1 vote, among others.
The presidential election petition number E005 of 2022 as consolidated with the presidential election petition numbers E001, 2, 3, 4, 7, and 8 of 2022 are hereby dismissed. As a consequence, we declare the election of the first respondent as president-elect to be varied under Article 143 of the Constitution.
Chief Justice Martha Koome, while delivering the judgment, affirmed that the decision was agreed among the 7-judge bench.
And also the orderly way the council, all the advocates and parties conducted themselves, they remained seated throughout the proceedings. That is the judgment of the court, a unanimous one. We shall issue a media summary to help the media summarize the case.
On whether the technology deployed by IEBC for the 2022 general election meet the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results, the Apex Court ruled that the scrutiny report by the judiciary did not reveal any security breaches as purported in the presidential petition.
Upon considering all the pleading submissions and the ICT scrutiny and inspection tallying and recount report, which fully examined the IEBC's result transmission system, RTS, we are not persuaded by the allegation that the technology deployed by IEBC failed the standard of Article 86A of the Constitution on integrity, verifiability, security, and transparency for the following reasons. 1. Whereas it is true that the KIMS kit failed in 235 polling stations, 86,889 voters were granted the right to vote manually, and the requisite forms 32A were duly filed. This happened successfully in Kibwezi West constituency and parts of Kakamega County. 2. While the audit report was released to the public 7 days before the 9th August election, the register of voters was used at the election without any apparent anomalies.
On whether there was interference with the uploading and transmission of Forms 34A from the polling station to the IEBC public portal, the 7-judge bench ruled that the evidence and logs provided in the petition were either outrightly forged or were obtained from 2017 general election.
No credible evidence was presented to prove that anyone accessed the RTS to intercept, detain, or store Forms 34A temporarily before they were uploaded to the public portal. The allegation that 11,000 Forms 34A were affected by staging was similarly not proved. 2. The allegation that IEBC, its officials and strangers used a tool to tamper with the Forms 34A before converting them to the portable document format, that is PDF, that eventually appeared on the public portal was sufficiently explained when IEBC demonstrated how KIMS captured and transmitted the image of Form 34A. Accordingly, we dismiss that allegation.
Whether there was a difference between Forms 34A uploaded on IEBC portal and Forms 34A received at the National Tallying Center and Form 34A issued to agents at polling stations, the Apex Court dismissed the affidavits filed by Arnold Odinga and Celestine Opondo showed different Forms 34A from the ones on the IEBC portal.
No credible evidence was presented to support the allegation that Forms 34A presented to agents differed from those uploaded to the public portal. The report by the registrar of this court confirmed the authenticity of the original forms in the sampled polling stations. The affidavits of Celestine Opio and Arnold Ochieng Oginga, while containing sensational information, were not credible, as the registrar's report confirmed that all the Forms 34A attached to those affidavits and purportedly given to them by the agents at select polling stations were significantly different from the originals, certified copies, and those on the public portal. The purported evidence of Celestine Opio and Arnold Oginga, sworn in their respective affidavits, are not only inadmissible, but are also unacceptable. It has been established that none of the agents on whose behalf the forms were being presented swore any affidavit, that there is nothing to show that they had instructed both Celestine and Arnold to act for them, yet the two have gone ahead to depone on matters that are not within their knowledge. This court cannot countenance this type of conduct on the part of counsel who are officers of the court. Though it is elementary learning, it bears repeating that affidavits filed in court must deal only with facts which an deponent can prove of his own knowledge, and as a general rule, counsel are not permitted to swear affidavits on behalf of their clients in contentious matters like the one before us, because they run the risk of unknowingly swearing to falsehood and may also be liable to cross-examination to prove the matters deponed. We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 113 and 114 of the Penal Code that swearing to falsehoods is a criminal offense, and two, that it is an offense to present misleading or fabricated evidence in any judicial proceeding.
On the part of Venezuelan Jose Camargo, who was purported to have gained entry into the IEBC server to manipulate the results, the Supreme Court termed the claims as hot air.
We turn to Form 34A for Gacharaigo Primary School, which was sensationally presented by Madam Judy Soweto, advocate, to show that one Jose Camargo accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air, and we were taken on a wild goose chase that yielded nothing of probative value.
On the postponement of elections, the Supreme Court ruled that the petitioners did not show enough evidence that the Electoral Commission acted in bad faith in postponing the elections.
As regards this allegation, it has not been shown that by postponing elections in the named electoral units, IEBC acted in bad faith or was influenced by irrelevant factors and considerations. From the explanation tendered, we are satisfied that the postponement was occasioned by a genuine mistake, which in our view could have been avoided had the members and staff of IEBC been more diligent when they went to inspect the templates in Athens, Greece, where the printing of ballot papers was undertaken. In the absence of any empirical data, we cannot find a basis upon which to conclude, as a matter of fact or evidence, that the postponement affected voter turnout, as a consequence of which the first petitioner alone, as a presidential candidate, suffered disadvantage.
On whether there was discrepancies between the votes cast for presidential candidates in other elective positions, the Apex Court ruled that the Azimio la Umoja One Kenya coalition did not provide sufficient evidence to prove the discrepancies were as a result of fraud.
A single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypothesis that since the number of votes cast for the president is higher than those for other positions, then without more, it must follow that there was fraud. We find that fraud is a serious criminal offense, and it must be proved beyond reasonable doubt under Section 5N of the Election Offences Act. It is indeed an offense for a person to vote more than once in any election. No unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions.
Whether IEBC carried out verification, tallying and declaration of results in accordance with the provisions of Article 138(3)(c) and Article 138(10) of the Constitution, the Apex Court, however, ruled that the court could not nullify the election based on internal differences and disputes.
They contend that by rejecting IEBC's results on grounds of opaqueness of the verification and tallying process, they called into question the credibility of the entire election. They further submitted that being in the majority out of the 7-member commission, their view should prevail and the election should be nullified. It is the petitioner's argument, therefore, that a dysfunctional commission cannot deliver a credible election. We note that apart from their 11th-hour denunciation of the verification and tallying process and their averments regarding the conduct of the chairperson, the 4 commissioners have not placed before this court any information or documents showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson. Critically, they have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, at the Serena Hotel press briefing, the 4 commissioners acknowledged that thus far the entire election had been managed efficiently and credibly. In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people are participating without hindrance, as they made their political choices pursuant to Article 38 of the Constitution? To do this would be tantamount to subjecting the sovereign will of the Kenyan people to the quorum antics of IEBC. This we cannot do. Clearly, the current dysfunctionality at the Commission impugns the state of its corporate governance, but does not affect the conduct of the 2022 election. In view of the foregoing, we are satisfied that notwithstanding the divisions apparent between the chairperson and the 4 commissioners, IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 10 of the Constitution.
Whether Ruto, the declared president-elect, attained 50% plus 1 in accordance with the Article 138(4) of the Constitution, the Supreme Court determined that Ruto made the 50% plus 1 vote as stipulated in 2010 Constitution of Kenya.
We have deliberated on this proposition and found that it is not mathematically sound and that the rounding off done by IEBC and the chairperson was correct. Consequently, we find that the petitioners did not provide a watertight case to warrant the setting aside of the results of the presidential election on the basis of not having met the threshold provided under Article 138(4)(a) of the Constitution. We find that it is, as such, on the basis of the foregoing formula and from the numbers provided by IEBC and the chairperson and the declaration by the chairperson of the President-elect on 15th August 2022, it is our finding that the declared President-elect attained 50% plus 1 of all the votes cast in accordance with Article 138(4) of the Constitution.
On whether there were irregularities of such magnitude as to affect the final result of the presidential election, the Apex Court ruled that the irregularities and illegalities was not sufficient to compel the court to nullify the election.
Although the petitioners have provided numerous averments pointing to possible irregularities and illegalities marked by failure of technology, arranged voter suppression, printing and utilization of Book 2 of 2, EU preparation by the IEBC and its chairperson, commission indiscretions, transposition anomalies, agent absence, and many others, we are of the view that the pointed illegalities and irregularities were not of such magnitude as to affect the final result of the presidential election.
Other reliefs and orders the court can issue, the Apex Court dismissed the petitions with each party bearing its cost.
Nothing stops the court from issuing orders or reliefs by way of recommendations. Indeed, since 2013, this court has issued many recommendations arising from the determination of 3 petitions challenging the election of the president-elect. The recommendations are meant to improve our electoral landscape and hence aid in the development of our democracy. In this regard, this court has been greatly aided by the contributions also of the Amici Curie, and the court places a heavy premium on those briefs that were filed and those which were admitted. This being a matter cutting across the public interests, we order that each party do bear their own costs.
Maisha Prime, Maisha Television, I'm Sharon Chepchumba.